Okay, so where we had finished subject matter jurisdiction. So this stuff is pretty simple, so you can study it on your own actually. Uh, we had done, okay, types of, one of the types of original appellate, okay, of course this is only there with, appellate jurisdiction is only there with the higher courts, so they can hear appeals, okay, and we'll talk about final order, interim orders as the next topic. And here you can see your listing of topics. Okay, so we're actually here at types of jurisdiction, original versus appellate. Yeah. Right. So here we have this is term called a curative petition, because normally for Supreme Court decisions you cannot appeal them, but you can try. This is an in-chamber petition, curative petition. It has been tried in several high-profile cases. Historically. So now, the other important point you have to understand is appeal is a creature of statute. So you don't have any appeal unless there is a provision in the statute. Okay, and this is also connected to the next point that we will study, which is so this is about original and appellate jurisdiction. Okay, which is there with the higher courts, and then please interrupt and ask a question if you think I'm going too quickly. Okay, so. And the next topic is the types of orders. Here we have that listed down as well. Types of orders, final versus interim. Interim is also known as interlocutory orders, right? What is the technical definition of a final order? It has to be an order which finally disposes of the matter which is before the court. Okay, these orders are passed by courts, and has to be done after hearing both parties. Generally, do not consider ex parte orders which are hearing both parties. So here we can write it as, teach you another legal lingo, which is, that is not ex parte, which is, ex parte is basically one-sided, one party has appeared and the other has not appeared. Okay? So there are certain cases where, depending on the type of petitions, like a speedy trial petition, you can do it ex parte, where the other party is not expected to be harmed by a speedy trial. So they will generally give it. But generally, we expect in a final order is that it should have finally disposed of the controversy brought before the court. And it should have been done after hearing both the parties, not just one party. And it should, most importantly, it must finally pronounce on the, and this is how you actually dispose of the matter, it must finally pronounce on the rights and liabilities of each party. So this is where you see the connection to the next topic as well, which is substantive versus procedural laws. Okay, so finally pronounce on the rights and liabilities of each party, which is basically what happens that when you come to a court for with a controversy, there is usually a dispute about between two parties on what their rights and liabilities are. Okay, and usually these are kind of like a zero-sum game. So if I'm fighting with you over something, then I have a right, like maybe I have a right to receive rent, and my right to receive rent, if I'm the landlord, is kind of like a zero-sum game with your liability to pay the rent. Okay. So it's basically like a mirror image of that. So this is basically what we're talking about, right? So this is how you come to a court with some kind of a dispute about what the rights and liabilities of the parties are. This is the language that we use in the law, when we talk about rights and liabilities of parties. This is important to understand. So you have to pick up the legal language, because you're doing a business program, you're going to be an MBA. So people would expect that when you talk about these matters, you don't talk like a layman. This is important in all subjects, actually, not just in law. That in all subjects, you pick up the technical language of the particular subject. Like when you do finance, there'll be certain technical language which you need to understand, which you must not use like a layman, but you must use like a proper professional, finance professional. So similarly here, these are the key words that you should pick up, which is the rights and liabilities of parties and a final pronouncement by the court on who has what right and who has what liability. Okay. So this is basically how you distinguish between a final order and so anything which is not like this, which does not have these properties, will be an interim order. Okay, so final orders are those which have these properties and they do these things. And so anything that is passed, any order that is passed by a court which does not have these properties will be an interim order. Okay, and so again, you can see that the definition of interim order is actually therefore a residual concept. Okay, so anything that is not a final order will be an interim order. Any order that is not a final order will be an interim order. And at this point, since just to jog your memory, when you encounter this word residual again, you should what you should do here is recall a couple of other concepts that we have studied, which are also residuals, which are net worth. If you remember, an accounting net worth is a residual concept. We showed you that. And then also we studied obiter dicta, okay, which is also a residual concept because you take the judgment, you extract the ratio decidendi, and whatever is left, that's your obiter dicta. So that's also a residual concept. Okay? So we just quickly recap here that we have two other residual concepts which we learned, obiter dicta and net worth. Again, as you can see, not really connected. One is law, one is accounting, but this is how you have to think. So we will deliberately make you jump between disciplines because you have to think like that all the time, right? As a business student, you have to be very comfortable jumping between various domains. That's what people expect from MBAs. Right, so that's final orders and interim orders. And if you go back now to the previous topic where we talked about appeals, okay, one of the things you will find a general thread in the law is, of course, appeal is a creature of statute. So if the statute grants an appeal, you will have that type of appeal. But generally, what happens is that generally the statutes will allow appeals. We can actually talk about this. So that's why I said generally, because sometimes there may be an exception. I'm not familiar with all the statutes. That's why I'm writing it this way. I'm hedging myself. Instead of writing a blanket statement without qualifying, I'm just writing generally so that it allows for the possibility that there may be some exceptions. So generally, statutes will allow appeals to higher courts only against final orders. All right, so this is where we come to final orders. Of course, there are exceptions in the Civil Procedure Code also. There are exceptions like this. You can file a revision in the High Court. But generally, the courts frown upon any appeal that is not against a final order. Generally, okay. So the appeal only against final orders, and then you have final orders explained in the next topic, which is they have these characteristics. Okay, these are all ideas that you should be familiar with. So remember that when we start the Viva sessions, I could just randomly ask anybody from any group. I would just randomly take any concept and I would just ask you on that, ask you to explain that concept. And so you should be ready to do that, and you will not really have an opportunity not much time to consult any notes or anything like that. So it should be clear to you. You don't have to memorize it. I don't expect you to memorize it, but you should be able to explain broadly what that idea is. Okay, so that's final orders versus interim orders. Then our next concept is procedural laws versus substantive laws. Okay. So here we have this definition of, first we define the substantive laws. Okay, so these are laws that define rights and liabilities. So once again, you can see the word rights and liabilities. This is the rights and liabilities, and then you can see the word rights and liabilities here again. So when you go to the court, you have a dispute about rights and liabilities. So usually what happens is you have substantive laws which have already defined the rights and liabilities, but there would be some kind of dispute about the interpretation, okay, of those statutes. Or sometimes the dispute is about some area which has not been addressed by the statutory law, okay? So that can also happen, but it's less common. Usually there is a dispute about the interpretation. So therefore, the substantive laws have already defined the rights and liabilities. So here's an example. These are all examples of statutory substantive law. The IPC is a substantive law. Okay, all kinds of the Contract Act, Income Tax Act, okay, transfer of property, partnership. These are all substantive laws because they define what the rights of parties will be in these types of transactions, okay, which are covered by these kinds of legislations. So essentially, this is why we say these are substantive laws, because they have the important property of they define the rights and liabilities of legal persons. We'll explain what legal persons are. Legal persons essentially are, we can talk about it here itself. We normally talk about it in company law, but I can just give you a so a legal person is either a natural person or an artificial person. So a corporation is, so let's say Airtel is an artificial person because it's a company. And say Sunil Mittal is a natural person because he's an individual. So this is how we define, and then both are legal persons. So this company, legal person, the personality of the corporation that we'll deal with in corporate law. But generally, it's better to use the word legal person, which covers both, all kinds of legal persons, artificial and natural. Right? So the Act defines, substantive laws will define the rights and liabilities. This is their property, the nature of substantive laws. And so what procedural laws do is they define the procedure to be followed, okay, when seeking to enforce these rights. This is basically the nature of the procedural law. So you have these rights and liabilities. So for instance, if you have a tenant and landlord, you might have, say, a Delhi Rent Control Act. That would be an example of a substantive law. That will define certain rights and obligations. That's a substantive law. So it defines the rights and liabilities of landlords and tenants and everything. So if there is some kind of dispute between the landlord and tenant, and usually it hinges on the interpretation, or sometimes, one of the parties just says, I'm not really interested in following the law, where in that case, of course, the other party can go to the court and get the court to, make him follow the law. So this is basically the kind of dispute you have. You have these rights and liabilities. So one party feels that their rights have been aggrieved, have been infringed. Okay, so they're aggrieved because of that. And so then you go to the court. And so basically, because of some actions of one party, of the other party, one party feels that its rights are infringed. And then it goes to the court. And then when it goes to the court to enforce these rights, it will have to follow a certain procedure because the court has certain rules. And so some of these procedures are laid out in all the procedural laws that we have. Okay, so some of these examples are procedural laws are, this actually should be written here. Examples of procedural laws, examples of procedural law, Civil Procedure Code, sometimes referred to as CPC. Then Criminal Procedure Code is referred to as CRPC. And then you have the Evidence Act, Limitation Act. Okay, these are all examples of procedural laws. Okay, so these are some of the examples that you have. The most common, the biggest, most important procedural laws are the CPC, the CRPC, and the Evidence Act, because this really governs your trials, both civil and criminal. Okay, so these are very important pieces of legislation. Now, the other thing to note here is that many of these laws are actually what we can call hybrid, just like when we discussed common law systems versus civil law systems, and then we said that common law systems, when they started in England, early 12th century, that time they were purely common law system because there was no parliament as such making laws, coming up with statutes and things like that. So it was just purely the judgments of on previous cases, and you looked at all those judgments and you looked at that was the evolving common law. So that was a pure common law system. But very soon, then eventually, not very soon, but eventually, England got a parliament, and parliament started making laws. So you had statutes. So eventually, what has happened now in the modern world, even those which we call common law countries like Australia, New Zealand, India, US, Canada, etc., these are actually hybrid mixed jurisdictions because they have both judicial precedent, which is the pure common law format, and they also have statutory law, which they have to follow. So in this similar way, in a similar way, many of the laws we look at are actually, even the ones we mentioned as procedural laws, they actually have certain substantive elements. So for instance, you remember that when we studied the Shabano case, we talked about section 125 of the CRPC. Okay. Now that actually is a substantive provision, although it talks about, it's really much more of a substantive provision. Okay, it talks about the rights that certain people have, like the wife, the parents, the children. They have a right of maintenance, and that actually right is being created by Section 125 of the CRPC. So in that sense, it is a substantive procedure, a substantive provision, because it is actually creating rights and liabilities. It is defining rights and liabilities for certain types of parties, and so the rights of all these people who can claim maintenance become the liability of the person from whom the maintenance is being claimed. Okay. In this case, the husband or the father or the son, etc. So you can see that although we say that these are procedural laws, they are actually, many of these laws can actually be hybrid. Okay. So like, for instance, in the Registration Act also, there is a section which actually says, there's a section which says, I think it's section 17, where basically it says that if you have a transfer of property, it's more than 100 rupees, and you don't register the property, then the transfer is void. Okay, so in the sense the transfer does not take place. So I might have transferred something to my brother, but I didn't register it, and it was required to be registered. So the transfer actually still belongs to me. It doesn't belong to my brother, it still belongs to me. So the transfer it has no meaning in the eyes of the law. That's what it means. Okay. So this is this is where basically we talk about the substantive. So that's although the Registration Act is considered a procedural law, it also has certain substantive elements because it is nullifying certain rights or preventing certain rights from accruing because certain procedures were not followed. So therefore, it also has elements of substantive law. But generally, these are what we call the procedural laws. So these are, as we said, these are hybrid laws. Okay. So now another question often comes up in litigation is which type of law is more important? Because sometimes there are certain procedural elements which have not been satisfied, but if you there are many types of procedural error. Sometimes it can be a grave procedural error, okay, which causes prejudice to the other side. Okay, that's generally the courts will not overlook that. But what we say in the law is there's a statement that is, procedure is the handmaiden of justice. So which means that procedure is to basically follow justice, like handmaidens follow the queen or other basically ladies in waiting. So procedure is subservient to justice. Okay. And it should be a capital, So this is what we like to say. So that what we mean by this is that the doing justice is more important. So we should not quibble about minor procedural glitches, and unless there is a prejudice to the other party, the court should allow these kinds of procedural errors, minor procedural errors, to be corrected, and make sure that justice is actually done. So this is an important statement. Procedure is the handmaiden of justice. Okay. Right. So, and of course, as you know, that if you go back to realism becomes, because here doing justice according to whatever the judge's view of justice is, this kind of a statement becomes more important for people who believe in realism. People who believe in formalism can tend to be more, particular about having the procedure be observed. But the people who believe in realism, for them, this kind of a statement is a nice statement to lean on, because then they can do what they want and just ignore the procedural requirements. So that's as far as substantive versus procedural laws are concerned. Okay, that takes. Let's see if we have. So in your spreadsheet here, this is like our general online workbook. I shouldn't call it a spreadsheet because each of these is a spreadsheet. It's actually an online workbook because it's got multiple spreadsheets. So here we have a general scribble sheet, and this is our topic list of what we are covering. And I'll try to keep it on through. Yeah. So if I basically freeze this, and then I'll try to. Yeah. So then I'll try to cover it, and then we'll put topic 2, unit 2 here, etc. So that'll be a good check for you when you're revising, etc., to see what are the topics we have covered. Okay. So here we have. Right. Then this is our last topic, I think, that is standards of proof. Okay. So this is also important to understand. Okay, so we have essentially got 3 standards. Yes, Samya?
So, what exactly are we trying to say with these minor versus major or grave procedural errors?
Well, basically, the operative distinction will be this: that a grave procedural error will prejudice the defense or the accused. Okay. This is latter category. It is talking about from a criminal perspective. Okay, so essentially you can say that grave procedural errors are those that have a material impact on the rights of the other party. Okay, so grave procedural errors have a material adverse impact on the rights of the other party. Okay, so if I've made an error and you're the other party in the suit, then if it's a grave procedural error, if my error, which I'm now seeking to have overlooked, but that has actually nevertheless had a material impact, adverse impact on your rights, okay, on the other party in the suit. Okay, so you can say grave procedural errors. Okay, so for instance, there's something called a doctrine of laches. If you are following, for instance, the election lawsuits in the US following the November 2020 election. Now, one of the suits was, I think it was in Wisconsin, I'm not sure, because there were many suits in different states, but there was this concept of doctrine of laches. Okay, I'm not sure if I spelled this. I'll just check that, but this is how it's pronounced anyway. So here it means that basically I have okay, where that means basically the party seeking relief, let's say in the court, okay, has kind of slept on its rights, which means basically like maybe I had a right to a certain property, but somebody was living on the property, and it's also connected to the idea of adverse possession. So I was basically, a person was living in my property. I knew about it. I didn't do anything about it for 10, 15 years, 20 years. And then suddenly after 20 years, I come and say, no, this property belongs to me. But by this time, the person has made improvements on the property and all this kind of thing. So now I have delayed my relief for so long that I have kind of slept. It is true that the property still belongs to me on paper, but I have delayed seeking of relief so much that now if the court seeks to give me, restore my rights, okay, on the property, this will cause a material adverse impact on the rights of the other side. So if they had, the idea would be that I should have actually done it very quickly. The moment I found somebody else living in my property, I should have immediately moved the court, and the guy would have been thrown out, and then he would have found some other place to stay. Now here he has kind of got used to staying there, so it is it is basically like adverse possession also. But the idea here is that the idea of laches is that you have slept on your rights, and now it has. This is a procedural error actually that I came to the court too late, but it is actually of the type that if the court now allows me to still proceed, that will have a material adverse impact on the rights of the other party. So generally, when the court is using doctrines, a principle like procedure as the handmaiden of justice. So the idea here is that the court should not overlook grave procedural errors. Okay, so when it's a grave procedural error, they should basically not overlook them. Okay, so let me just talk about. Especially such errors are minor, okay, which is given here. Okay, major versus minor versus minor, minor versus major. Major means those which are grave procedural errors. So if the errors are minor, then they can apply this kind of a principle. Okay, but if it's a major procedural error, so they have to look at basically this is the idea because the court seeks to be fair all the time. Okay, so prejudice to the other party, that's the main thing. Prejudice is also a legal term. You have to understand it and use it in the right way. Okay, prejudice to the other party. Is there any prejudice being caused to the other party? Okay. So this is basically the idea here. Is it clearer now, Soumya?
Yes, sir. Yes, got it.
Okay. So the main operative word is this: is there any prejudice to the other party? That's the main thing. Okay, so here we come to the last topic, which is such standards of proof, which is now we've got three standards actually: one in criminal trials and two in civil trials. Right. So the criminal trial standard is obviously beyond reasonable doubt. You might have heard about this, and so that means that when you're proving somebody guilty, like here they're trying to bring Nirav Modi to trial. So they'll have to prove in court. Now, in the UK courts, they have managed to establish that there is a prima facie case of fraud. Prima facie case means on the face of it, on the surface. But that's not enough to win a trial. That's only enough to allow the trial to proceed. Okay? So therefore, the judges said, now, of course, there are many options he has. He can still delay it. But eventually, I guess if he comes here, but even when he comes to India, there will be a trial, and the prosecution will have to prove beyond a reasonable doubt, okay, that he actually committed this fraud. Then there was this conspiracy. They have leveled this conspiracy charge also. So all of these charges will have to be proved beyond reasonable doubt, which means you have to put in so much evidence that you have to submit so much evidence to the court that the judge will basically say that I can't think of any reasonable doubt that I have about this person's guilt. Okay, so then only then will the person be convicted. Okay? So this is the idea that the standard of proof in criminal trials is very high, and of course the reason for this is that normally you have a jail sentence as a punishment in a criminal trial. So when you are going to deprive somebody of their liberty, so you better have some pretty good proof. Okay, so that's the idea behind why you have such a high standard of proof in a criminal trial. Okay, this is considered the highest standard of proof. Okay? And then the other term that you should also be aware of is that in most of these Western style, even in the civil law countries, I would expect this to remain, that there is a presumption of innocence. So even in the case of Nirav Modi, when he comes here, until he's actually convicted, the whole trial has to end. Then you'll have the final arguments, and then you'll have the arguments for sentence. So after the final argument, then the judge will pronounce his verdict, whether he's guilty or not on each charge. Okay, so that's when the conviction actually happens. All right. So once he's convicted, then there'll be a sentencing. So until he's actually convicted, there is a presumption of innocence. So we assume that everyone is innocent until proven guilty. Okay, so this is also another general principle that applies in most countries. That so there is a very, very high bar to putting somebody in prison, making turning somebody into a convict, etc. So that's the standard in a criminal trial. Now, in a civil trial, we have two here. You can read the standards here while I drink some water here. Okay, just read that. All right, so 2 is a higher standard than 1. Okay, clear and convincing evidence. Okay, obviously that's a higher standard than preponderance of evidence. You can think of it in percentage terms if you want to just remember it in percentage. Don't actually think of it like this because don't say this to anyone, but in your own understanding, very loosely, you can say this is kind of like close to 100% sure, and this is kind of just about like 51% sure, whereas this is kind of like 67% sure. So this is like what you would call, this is less just a majority kind of, if you're talking about voting in a legislature, this is a unanimous kind of vote, almost similar to that. This is just a simple majority kind of vote, and this is a what we call a super majority. So this is a much higher standard of proof, but it is still not as high as this. Okay. So in a civil trial, you have two standards, which is preponderance of evidence, a weaker standard, and then you have clear and convincing evidence, which is a higher standard of proof than this one. Okay. These are just the standards of proof, which is basically the extent to which you have to convince the judge with your evidence before you get a verdict in your favor. All right. So this is just on the topic of standards of proof, which you should also be aware of as a basic. Some of the here I've tried to in this section just try to cover certain basic legal terms which you should all be familiar with, even as business students. Okay. All right. So this ends your section. So I've put in a session on. I've put in an optional note on writs. You can read. This is very interesting stuff, actually. But if you want to read, this is not going to be part of your syllabus. Okay, it's for you to read. You can read it if you want. Okay. So so that ends your section on the unit 1, actually, jurisprudence and legal theory. Again, a very unusual section, actually. Normally, business school lab courses don't have this, but I felt that this is required because otherwise you don't really have the many of the weapons and the context to understand your actual cases. So we now go on to your second unit, which is contract law. So this note is now in your folder. Okay, so let's go to this. It's a little bigger. So we'll start contract law now. These are some very small font here. I just didn't want to didn't want this to take up space. This is a decent website, actually, the income tax website. You can get a listing of a lot of the acts here. These are maintained by Taxman, so these are not too bad in terms of being very updated. These other ones actually are not so regularly updated, although they're quite user-friendly to access. So just be a little careful when you really need to know the updated information. Just use this one. India Code is the best, actually, but this is also not too bad. Here you can see all these acts. We don't have all the acts, but they have pretty much. They have quite a few of them. Okay, although it's only the income tax website. They have a lot of these acts. So you can refer to these. And then, as Naireth asked about the judgments, the juris thing is here as well. And you have this. So let's get into contract law. This is the first introduction to the first actual business law topic, a particular legal topic. Okay, so here you have, so I'm going to just refer to this as ICA because this is a very big word. I don't want to keep saying it all the time. And so here you can see that this is actually a very interesting piece of legislation because now, the British do not have a Contract Act. They never had one, and they don't have it today either. They do have an Unfair Terms of Contract Act, but that's a much smaller act. So what they did for the Indians is something they didn't have for themselves. And this, in fact, is in many ways, is actually the codification because it was written in 1872. It actually codifies the English common law of contract as it stood at that point of time. So from that point of view, it's quite an interesting document. And so you can see certain cases, the ratio of certain cases has actually come into the Contract Act as a particular section, okay, because that's how the common law was evolved through cases and the ratio decidendi of those cases. And then that's come into, so it's a very interesting document from that when you see it from that point of view, okay. Now, here you have, this is the, what we call the general law of contract, okay, or, the law of general contracts. And there are certain what we call special contracts, okay? This is basically, they're also all contracts, but there are special types of contracts. So one is basically the sale of goods, okay? This used to actually be part of the Contract Act. Okay, now they stripped it out in 1930. In 1932, even the Partnership Act was also part of this earlier. So it was taken out because these are all types of contract. Partnership is also a type of contract. So Now, this is partnership is also a type of contract. Now, these are the sale of goods is an example of a special contract. We call it a special contract. Agency is also a special contract. So, like say, Videocon might employ some ABC distributor as an agency, as an agent. So the relationship between the two will be defined as under the law. It's going to be governed by the law of agency. Agency is also a kind of a special contract. Okay. So so let's look at this now. The first observation that we have here is, now you see in just to relate to the normal discussion, the layman's discussion of contracts. So generally you will hear that there's there's an offer and acceptance, and then there's a contract form. Okay, so this kind of language actually you don't find in the ICA, but you do find in the Sale of Goods Act. Okay. You can see here this they have defined what this is. I don't know why this is here. Here, what is a contract of sale? Okay. This is not so important for our present discussion. The more important part is this. Okay. So how is a contract made? Okay. So when a contract is made, it means what they're talking about is the formation of the contract. Okay. This is a very important event because as soon as the contract is formed, your legal liabilities are crystallized. Your legal rights and your legal liabilities are all crystallized. So you might have a contract to deliver sugar, maybe 100 kilograms of sugar. That delivery is actually 6 months later. The payment is also 6 months later. But as soon as you form the contract today, the obligations are crystallized. Okay? It doesn't matter that the delivery is much later. That's why the point of formation of the contract is very important. Okay? So here you can, you can see here that this particular kind of language, offer and acceptance, okay, is there in the Sale of Goods Act. You can see here it says, contract of sale is made by an offer to buy, sell, etc., and the acceptance of such offer. So when you give an offer, when there is an offer made and then an offer is accepted, then you have the formation of the contract. So this is where you go for this kind of language. So now we start with the Contract Act. If you look at the India Code part, okay, we have all these sections. Actually, I think it's better generally to get a proper. They put on this. Because the overview kind of thing comes a little easier with some of these web-based acts. Yeah, this is better for an overview actually, but generally the text is not updated. Thankfully, Contract Act, there are not too many updates, not too many amendments, but it becomes very important when you're looking at things like CRPC and CPC and Income Tax Act. There are always amendments coming through. So you can see that this is a good way to look at the overview. Okay, so Chapter 1, etc. And so we'll be looking mainly at Chapter 1 and Chapter 2. Okay, so you can keep this here. So we look at, if you look at Chapter 1, okay, before that there's a preliminary section which has an important thing called the interpretation clause, which is not very common in most legislation. You'll see that this is where you define all the critical terms. Okay, so in the Transfer of Property Act, you'll find there's a section like Section 2, usually Section 2 for everything, for most acts. There'll be an interpretation clause, and then basically that'll have definitions like what is notice, what is property, what is movable property, etc. All those will be defined in there. So those important definitions for that body of law, they'll be contained there. So here we have certain important definitions. Okay, so I'll just show you first. So the first thing we're studying actually on the contract, on the ICA, is what we call the interpretation clause. Okay, that's what we are studying first. So what we are doing is, I'll just show you the, let me just show you by PDF. Probably it's better this way. Yeah, so it is something like this. Okay, so the interpretation clause goes like this. Okay, so what I'm going to do actually is that I'm actually going to teach you the interpretation clause in a different sequence. So what I've done is I've taken only these words, these kind of clauses, okay? But I have not used the sequence that is there in the ICA, okay? I have jumbled it up and I have sought to explain this to you in a different way. So you have two options, okay? In the class, I'm going to explain it in my way. And if you feel that that's not very clear, you can always go back and look at it from the, read the act. Because anyway, I'm going to be discussing each of the provisions that are there. Okay, so if you feel this arrangement is better, you can study it in this way. Okay, so I'll just come. So I've reproduced this so that you don't have to actually go to the act. And here there's a problem with my margins, things are spilling over. But anyway, we're not looking at this. This is actually the text of the act, which I have reproduced so that you can read it directly on this page. Okay, now this is what I'm doing in the interpretation clause. Okay, section 2. I'm going to study it like this. Okay, and so I have looked at each question. I've looked at certain important questions which I've put in this kind of a color-coded system. And so what you have here is so the first question I'm going to ask is this is the Indian Contract Act. The first question I'm going to, so this is going to be like like those Russian babushka doll systems, those toys that you have. Right? You have one big babushka doll and you open that and you get another one below with the smaller size and you keep on opening and then you keep on getting smaller dolls. So it's just kind of like that kind of a sequence, okay? They keep asking questions and then the answers create more questions. Okay, so here you have the first question is what is a contract, okay? And the answer is to be found in clause H. Okay, so remember these are not things which I have written. This is actually just taken from the act. I'm just jumbling up the sequence. The first question I'm asking is what is a contract? Okay? And the answer is, well, a contract is an agreement. Here you can see enforceable by law, all right? So agreement enforceable is the thing, but I've just highlighted agreement because I want to then point out that, well, if you answer the question like this, then I have to ask you a next question, which is what is an agreement? Okay, so, well, so let's see what is the answer to what is an agreement. Okay, here you have that in clause E. Okay, it is every promise, every set of promises forming the consideration for each other. So here, if I put in something in full like this in capital letters, that means it's my insertion. Okay. So we'll come to that part later, but let's just read what is there. So what is an agreement? Here you have it's in clause E. So agreement is being defined. Notice that in defining agreement, again, they are using other technical terms. Okay. They're using a term like promise. Okay. Set, we understand. So set of promises, but we need to know what a promise is. And then they're using another technical term called consideration. Okay. So consideration for each other, that's an agreement. Okay. Now set of promises, yeah. So what we are saying is this actually should be here, this writing. This is again my writing. This is not from the act. This is actually not part of the act, of course. This I've just written as an explanation. Maybe I should. Right. It's just a kind of explanation, all right? So is it every set of promises? So here again, I would say every set of promises, so you can just focus on this, that includes every promise, okay? Because even one promise can be said to be a set of promises. So then, so every set of promises forming the consideration for each other. Okay, so you have to. So what is basically meant here is that it's talking about so promises which form the consideration or part consideration for each other are reciprocal promises. Okay? So. Yeah, actually, now I understand why it should have been there because this year they're talking about part consideration. So initially I had put it in the right place. I forgot about this part. Okay. So what are they saying? They're saying that to understand this language, because it's pretty old language. Okay, remember none of this stuff. Most of it is actually 98% of it has not changed since 1872. So it's very unusual kind of language. So you got to get used to it. So what they mean here is, like, if you have to imagine there's a set of promises on one side, and then there's a set of promises on the other side. And so this is the consideration for this, and this is the consideration for this. Okay, that's what it means. Every set of promises forming the consideration for each other is an agreement. So this is how you would understand it. You have a set of promises on one side. So then what is consideration? We'll come to that later. Okay, so we have set of promises forming consideration for each other becomes an agreement. Okay. And then they've defined another term, which is reciprocal promises. Okay, which means promises which form consideration or part of the consideration. Okay, promises or which form the consideration or part of the consideration. Now this has introduced another little curveball into the equation, because they have now started talking about part of the consideration. Okay, now what will happen is, here the reason, now you understand why they have defined a reciprocal promise. So in order for promises to be reciprocal, they don't have to represent the full consideration for each other. They can just be part consideration. So one of the promises can be full consideration, but this promise, one particular promise, which is not full consideration, can still be called reciprocal to this, even if it is a part of the consideration, okay, for the other promise. Now this introduces a slight complication, and it tells you why I put in this word here. I think that the drafting should have actually, because just after E, they have introduced the concept of a reciprocal promise. And then they've introduced the idea that a promise might form a part of the consideration for the other promise, okay? So now what will happen is, if you're saying even a part consideration is a reciprocal promise, okay, then what will happen is, if you have, if you write this word, see, they have not written full in the act, in the legislation. They've not written full. They've written only forming the consideration for each other. Now remember the rule that I taught you. If I say DSB students, I did not qualify it by saying male students or female students. I said DSB students, which means in that class, okay, of DSB students, without qualification, that word refers to all the subcategories in that class. So when I say DSB students, it refers to both male and female students. So this is how you interpret language. Okay? So this is not my opinion. This is just a rule. Okay? This is the only way to reasonably interpret language. So if you want to refer only to female students, then you must write female DSB students. All right. So therefore, here you have not referred to part consideration. You have not used the word full consideration, which means it could also be part consideration. Okay. But this statement would then not be correct, because if you have promises which form only part consideration for each other, they do not constitute an agreement. Okay. So therefore, I'm saying that the correct language here should have been full consideration, because they themselves have introduced the idea of part consideration. So therefore, they should have removed that doubt here and said only promises forming the full consideration for each other will constitute an agreement. Okay, so that's an important point to understand why I'm saying full. Okay, there should be a full here. Okay, now another thing you can say, combining again. So these exercises which we are doing. Why am I making you go through all this? Who cares what I think? Actually, that nobody has mentioned all these things before. Okay, why am I saying all these things to you? Because I'm trying to sort of intellectually provoke you and force you to think in a more analytical way. And that is the whole goal of the program, is to basically to develop critical thinking and logical thinking, and to develop those faculties. So I'm forcing you to think in these terms. Okay, and that's the idea behind it. So another thing along those lines, another thing we can do is we can take E and F together and see if we can state this definition of the agreement in a more elegant way. Elegant means in a leaner way, using fewer words. Okay, so if we can have a little proviso or assumption, okay, that the reciprocal promises form, let's write this as a proviso, okay, at the end. Proviso will be at the end, provided that the reciprocal promises form the full consideration for each other. Okay, we can say, okay. Then we can put this here as a proviso. So proviso will go after, okay, provided. So this also gives you an understanding of how legislation is written, okay. So legislation is written like this, in this kind of structure. One of the ways they write it is that this will be now called a proviso, provided that. So I make a statement and there's a proviso after that. Well, the objective here is to indicate to you that I don't expect this statement to be true unless the proviso is also true. Okay. So I'm kind of hedging myself. I'm making a kind of an unqualified statement, but I'm kind of qualifying it later on and saying, provided that where the reciprocal promises, provided that this language will have to be changed, because earlier I was putting it in the front and now I'm putting it at the back. So provided that the reciprocal promises always form the full consideration for each other. There I've covered myself now. Okay. So my statement is true. We can combining E and F. Okay, we can say that. We don't have to write this actually. We can say that. Reciprocal promises form. You see how lean this is now. Okay. Reciprocal. Actually, what is the point of writing? We can say that. I'm going to put this in. This is going to be in lowercase. All right. And it's going to be in brackets so that we don't need to really worry about this. We can say, obviously, we can say it. Okay, combining E and F, what is the real net effect of combining E and F? Okay, which is that we say that reciprocal promises form an agreement. Okay, reciprocal promises form an agreement. What we have done is we have taken this long sentence in section E, clause E, and made it smaller. We can basically replace clause E by saying reciprocal promises form an agreement. Okay, you can see how lean it is. Okay, in terms of a definition of an agreement. So I have combined the idea, and then you can see once again why I have used this proviso, because these reciprocal promises, the idea is that the reciprocal promises must always form the full consideration for each other. Okay? Because only then will you have an agreement. Okay, only then can you say that they form an agreement. Okay, and these are reciprocal promises. So although part consideration would also be a reciprocal promise, but I have put a constraint on it and said that I'm only dealing with those reciprocal promises which are full consideration for each other. Okay, so that's what the purpose of the proviso is. So I have narrowed down the set over here. Okay, reciprocal promises, set of reciprocal promises. I've chosen a part of it, those which are the full consideration. And then I just made it a simpler statement. Reciprocal promises form an agreement. And what is the reciprocal promise? It is a promise which forms the consideration for each other. Okay, those are promises which form the consideration for each other. Okay. So this is the structure of this response. Okay, agreement, and then we have essentially by putting in this proviso, we are now further narrowing it down and saying agreement is basically reciprocal promises that will form an agreement. That further problem remains: what is a reciprocal promise? Okay, now what is a promise? Okay, reciprocal promise we have understood, but we did not define promise. Okay, so therefore we have to now define promise. Okay, we have to ask this question. Okay, so what is a promise? All right, here you can see. So we are going in this sequence. Okay, so to help you understand the way I've dealt with this section 2, I put all this stuff in blue because there are some other questions in between. Isha asked a good question actually in the other class, so I've answered her question also over here. I'll try to later on, if possible, I'll move it to a different note so that it doesn't interrupt the flow. But right now it's inside there. So I have tried to make these questions stand out as we go through the sequence of questions to understand the whole of section 2. So what is a promise? Okay, so we still need to understand promise. So what is a promise? Promise is when the person to whom the proposal is made, okay, okay, this is actually talking about proposal. Okay, so basically for our proposal, this is the whole of section of clause B. Okay, but we are going to focus only on this. This is dealing with both the acceptance of a proposal, okay, and when is a proposal accepted, and that is when the proposal is made to a person, and the person to whom it is made, he signifies his assent to the proposal. It's kind of his agreement to the proposal. So a proposal would be like, okay, so I offer to clean somebody, take care of somebody's garden, okay, 3 times a week. Now that's a proposal, and the other party, if they agree to that, then okay, because maybe they need the garden to be cleaned. So they agree to my proposal. So that's his assent to my proposal, and then the proposal is accepted. Okay, and so what they're saying here is that what is a promise? When I ask them what is a promise, what they're saying is a proposal, when accepted, becomes a promise. Okay. So now you notice at each stage what is happening is they're answering the question in such a way that they're using another new term to answer the question. So which is forcing us to ask a question about that new term. Contract, agreement, then promise. Then what is promise? Then proposal. Now we'll have to ask about a proposal. Okay, what is a proposal? So now you have promise. Promise is basically what? A proposal accepted becomes a promise. And they have also defined what constitutes acceptance. Okay. So you can see this. So what constitutes acceptance? His assent to the proposal. Okay. So this is proposal, and accepted becomes a promise. So then the question is, what is the proposal? Next question is, what is the proposal? All right. So here you can see there are 2 people, one person to another. One person is signifying something, so there is a communication of some sort. Okay. Maybe even non-verbal or something. So you have to be very broad in terms of communication, types of communication. One signifies to another. What is he signifying? He's signifying his willingness. Okay, willingness to do what? To do or abstain from doing anything. Okay, so this also should be. Okay, so this is again an important idea in the law, which you'll find that generally in the law, when we talk about acts, we also include omissions. So if I fail to submit my IT return, that's also an act in the eyes of the law. Okay, I submit my income tax return, that's an act. I fail to submit when I am actually required to submit, that's also an act because it's an omission. Okay, it's a material omission. So therefore, generally in the law, when we talk about act, we use the word act. It includes not acting as well. It includes failure to act, etc. So therefore, we say willingness to do something or to abstain from doing something. Abstain means to refrain from doing it. Okay. So I abstain from drinking coffee for the next 3 days. So I don't drink coffee for the next 3 days. Okay. Or I drink 6 cups of coffee today. I promise to drink 6 cups of coffee today. Okay. So this is basically what is happening. There are 2 people. One person is indicating to another person that I'm willing to do something or I'm willing not to do something. Okay. So basically, you can see here, it is very similar to what we discussed in the proposal, in the case of the promise, when they were defining the acceptance of the proposal. Okay. So here again, we can use the same example. Okay, let's say I am trying to earn some money in my summer vacation by taking care of somebody's garden, and that I know that the person would like their garden to be taken care of, and maybe they're very old, they don't have the capacity to get the garden and do the gardening work themselves. Okay, so I'm signifying to that person that I am willing to clean your garden 3 days a week. Okay, so this is an example of active to do, not to abstain from, but to do. So I signify to the other person that I am willing to clean your garden. Okay. And why am I signifying this? Like, I'm not signifying, how did I come up with this idea that what I'm going to indicate to this person is that I'm willing to clean his garden, because I thought about what would appeal to him, because the objective here is to obtain, with a view to obtain the assent of that other, the other person. All right. To such act, actually there should be a comma here, right? So to such act or abstinence, okay, he is said to make a proposal. Actually, there should be actually a dash here. Okay. But anyway, we'll leave it all here. So this is the idea. So here we have to understand that there are two people. One person is signifying to another person his willingness to do or not to do something. Okay. And what kind of thing is that he's referring to, that he will do or not do? It's a kind of thing that would be of interest to the other party. It's just not like I go to another person and say, I go to this old person who needs his garden to be cleaned, and I tell them, I'm willing to complete my PhD. So he's not really going to be interested in that, because it doesn't really mean anything to him. So I'm only going to make a proposal to the other person of a type which will be of interest to him. So I know that he needs his garden to be cleaned. So therefore, I make a proposal to him which is likely to be of interest to him. So my intention obviously is to obtain his assent to my proposal. That is his agreement to my proposal. Yes, please clean my garden. I was looking for somebody to do it. I'm glad you came along. So please clean my garden. Yeah, that would be great. So this is basically what's going on here. Two people, one person is figuring out what the other guy wants and proposing that he will do this job for the other person, right? And hoping to get his agreement on that. So here one person is making a proposal to another person. So you can see now we are kind of reaching ground level, because they are not using any technical term. So we can understand the proposal, and we don't have to go into another further word, which we have to dig into to understand its meaning. So proposal is now fairly clear. Okay. Now there is another term here, in another clause here in C, okay, which is clause C. Defines something called a promiser and the promisee. Okay. Now the person making the proposal is promiser. The person accepting is a promisee. Okay. Now, actually, here again, I'll mention something to you, but I don't want to confuse you here, okay? Because I'm playing around. I'm trying to basically intellectually provoke you by making these kind of statements. These are my observations about where I feel there are logical problems. And so I'm a little bit apprehensive here, in the sense that I do want to make you think, but at the same time, I don't want to confuse you. Okay, so this remains the law. Okay, whatever I'm going to say now, that is just like kind of we are playing fun, and it's a fun and games thing between us. Okay, but you have to remember the law is what this says. Okay, so if somebody asks you according to the Contract Act, who is a promiser, and then the answer would have to be the person making the proposal is the promiser. The person accepting is promisee. Okay, so I'm going to make a couple of statements here. Okay, that here. Okay, so let's say the first thing is basically, where did I write this here? Okay, I didn't. Yeah, so we'll come to this. So let's understand this first. Let's understand the contract law language first. Then I'll talk about the, let's say, curveball. We can call these curveballs. Okay, curveball kind of intervention. Okay, where we have a discussion about something unusual. Okay. So what you have to understand is in this, so let's go back to this example here in the case of the gardening proposal. Okay. So one person is signifying to another is willingness to take care, to do the garden 3 days a week. Okay. Now, in this case, he's the promiser, and he's willing to, he's indicating his willingness to do that job. And of course, the kind of job that is likely to appeal to the other party. So he has an expectation that the other party will also make some kind of a return proposal, which will provide the incentive to this guy to do this job, okay, to take care of the garden. Okay, that's how transactions work. It's all about exchange. Okay, so he's exchanging his services, and he will obviously expect some money in return. So here, what's going to happen is, if this contract goes through smoothly, what will happen is, this proposal will be conveyed to the old person who needs his garden to be taken care of, and he says, yes, please do that. It's and I'm going to pay you, let's say, $100 a week. And then they can bargain about it. Let's assume there's no bargaining. It's $100 a week. So the guy thinks that, okay, $100 a week. Now, why is he making a proposal of $100 a week? He must have some kind of idea that that is kind of like the market rate, because he also wants to now obtain the assent of the person who is going to do the gardening. Okay, so therefore he wants to obtain the assent of that other person. So he will propose something which is close to the market rate. He will not really propose a ridiculously low price, because he knows then that the deal is not going to get done. So this, you can see here that in this you have all the economic incentives also built into this language, that we try to make a proposal when we are trying to set up some kind of economic exchange, where this is all business law. So you have to understand it from that point of view, that there is some kind of the whole economy runs on exchange. Okay, exchange is critical to the whole economy. So everywhere people are exchanging services and goods, okay, for money. And so in a modern economy, you have money. Earlier, you would have had barter. So here what is happening is the person figures out what the other guy wants and makes a proposal and saying that, okay, I'm going to do this for you. And then the other guy, okay, says, okay, this is what the market rate is. So let me make a proposal to pay this guy so much. Okay, so what is happening here is, the point I'm trying to make is that so here basically, when the clause C says person making the proposal is promiser and promisee, they have not clearly spelled it out. What they should have actually made even clearer is that in a properly formed agreement with only two parties, let's take out the bilateral agreement. Now, a party will be both promiser and promisee, because it's once it is formed. Okay, if it is formed, that means there is a reciprocal promise. Okay, a reciprocal promise means proposals have been accepted, and those proposals are full consideration for each other. So what happens here? Person making the proposal is a promiser, and the accepting is a promisee. Okay? So here, the guy who's going to do the garden, when he makes the proposal, he is the promiser. Okay. But when the guy whose garden is being done, the old man whose garden is going to be taken care of, he makes a proposal, I'll pay you $100 a week. For that proposal, the guy who's going to do the garden becomes the promisee. Okay? In the earlier one, he was promiser. So the point I'm trying to emphasize here is that in a properly formed agreement with two parties, you will find that it depends on which proposal you're looking at. Okay, so the party will be a promiser for one proposal and a promisee for the other proposal, because you will have two proposals, flowing from each side, one proposal flowing from each side, and total of two proposals, and both of those will have to be accepted. When those proposals are accepted, they will become promises, and if they are the full consideration for each other, they will become an agreement, if you see. Okay, if they are full consideration for each other, they will become an agreement. Okay, and then if that agreement is enforceable by law, then it will become a contract. Okay, so this is how the whole thing is supposed to work. All right, so you can see the point here I'm trying to make is that in this party will be, depending on which proposal you're looking at, the party will be, for one proposal, it will be a promiser, and for the other proposal, it will be a promisee. So this is also important to understand, just to be clear about. I think it's pretty obvious, but just to be clear about that. Okay. So the curveball that I wanted to throw in here is for your consideration, just to have some fun, is look at this language here, person making the proposal. Okay. Should actually is it better to write this way, that person making the proposal is called the proposer, right? You have a person from Haryana, you don't call him a Marathi, right? You call him a Haryanvi. You're making a proposal, so you should be called a proposer. Okay, so this is where my objection is. Okay, so you're calling, and why am I saying this objection is important? Because it's not true that all proposals are going to become promises. Because remember, in order for a proposal to become a promise, it must be accepted. It is not true. I could go to somebody's house and say, I want to do your garden. I would like to take care of your garden 3 days a week. Person may not be interested in that. Okay, so that's a proposal which is not going to be accepted. All right. So therefore, it is not true that all proposals will necessarily will be accepted and become a promise. Okay, so therefore, I feel that it should have been, if you're saying the person making the proposal is called the promise, it should be called the proposer, and the person accepting the proposal should be called the proposee. I'm not even sure if this is actually a word, but we can always have it. You can have drawer and drawee, okay? Offerer and offeree, so why not proposer and proposee, okay? So this is what I'm proposing. Let's make it more interesting and say this is what I'm proposing, okay? So this is the point that I wanted to make here. This is like a curveball, okay? So please remember, this is not the law. The law is what is in what the legislature has written, but I'm trying to provoke you by making you think in these terms, that if you're making a proposal, you should only be called a proposer. And once the proposal is accepted, okay, then you can say that he's a promiser, okay, because then that proposal has now become a promise. So after the acceptance, you can call him a promiser, and the person accepting, you can call him a promisee, okay? It's actually not, here I'm not suggesting that the person, because once you accept, you're already a promisee, yes. This is not correct. What I actually meant to say was one more thing here. That the opposite of, just go on. Yes, Aditya, there was some background noise. Aditya has pointed out correctly. Good. Always do that if I go, but I just said that I would go on mute. Okay, so I just went on mute and started writing. Okay, so that's what I try to do when I go on mute. I just show you that I'm still alive, and I keep writing. Okay, so and so you can see here what I was trying to suggest in my curveball, that person making the proposal is the proposer, and person to whom so not the proposed person accepting the proposal. Okay, this part is correct because once you accept, it's a promise, and so then you can be called a promisee. But because it's not necessary for all proposals to be accepted. Yes, Aditya? You had a question?
No,
Aditya?
sir. No, sir. By mistake, I did so.
Oh, it's okay. So this is the point that I wanted to make. So a little bit of a curveball. Okay. The idea is to basically make you think in a very critical, basically stimulate the habit of getting into the habit of critical thinking and logical analysis, right? So this is as far as this part is concerned. So you can see now what has happened. And through all this, you have got, okay, there is one more part which has to go on into, but before that, I'll just repeat one part here. Okay, so this is the proposal that I had for better drafting of this. Okay, and then after the promise is accepted, then you can, proposal is accepted, then you can call him the promiser. But before that, he should be only called a proposer. Okay, now this is again just my thought, so you have to keep it in a separate box in your head. Okay. And remember what the law actually says. All right. Now, here's another question. It's a question that Isha asked, which is a good question, actually. And we had this following discussion. So I'll just share this with you. And later on, I'll try to take it out. But otherwise, what I will do is, so let's call this curveball 1. And let's call it, so let's just call it questions is fine. I'll put this in italics also, so that all right. So our question was, what is the difference between proposal and offer? Now, because this word has not been used in the Contract Act, but we have seen this in the Sale of Goods Act, the word offer. So this question is a good one because it's they sound quite similar. Okay, but so let's examine this question in detail. All right. So first, let's understand what is an offer. So we find this word in the Sale of Goods Act. You can see here in Section 5 talks about contract of sale is made, an offer to buy, offer to whatever, buy, sell, and acceptance of such offer. Okay, offer and acceptance leads to formation of a contract. Okay. So basically, what we can do is we can take Section 5 of the SOGA and come to this conclusion that an offer, what is an offer? An offer is that the acceptance of which immediately creates a contract, because that's what the language says, that when an offer is made and then there is an acceptance of that offer, that creates a contract. Okay, which means here again what is meant to indicate is crystallization of the legal obligations of the parties to the contract, right? At this point of making the contract or formation of the contract. Right. So now this is one. Now this is so an offer can be that which the acceptance of which immediately creates a contract. Now on the question of the proposal, what is a proposal? The question is different between proposal and offer. On the question of the proposal, we could consider one scenario if it is also true that because we have seen offer, acceptance of that creates a contract. If we could say the same thing about a proposal, that a proposal when accepted becomes a contract, okay, immediately creates a contract, then we would be able to say that there is no difference between a proposal and an offer because they both have the same properties, okay. But is that really the case? Okay, so let's see what is happening in the case of a put a paragraph here. What is happening in the case of a proposal? So what happens when a proposal is accepted? Okay, it becomes a promise. Okay. Now, is that sufficient to create a contract? No, because we need what else? We need from every promise, set of promises forming the this clause, section 2, clause E. We need this. In order to go to an agreement, we first have to, so the question is, does it become a contract? The answer is no. A proposal when accepted becomes a promise, but that is just one promise, okay? So it's not sufficient to create a contract because to get to a contract, we have to eventually go through an agreement, okay? And then get to a contract. And then what you can see here is that what else do we need? So you can ask yourself, fine, we got a promise, what else do we need? What we need is what clause E says, okay? We need a set of promises. Basically, we need reciprocal promises forming the full consideration for each other, okay? Even that will take us only to an agreement. Just to get to agreement from one promise, we need a reciprocal promise. And we need it to be true that these two promises, the reciprocal promises, will form the full consideration for each other. And even that takes us only to an agreement, okay? So you can see how many steps away it is, okay? So it's one step away definitely, okay? Because here offer straight away becomes the contract and acceptance, okay? Now you've got one step more to go, which is agreement. You need to go to an agreement where you need to find another promise. These two have to form the full consideration for each other. Okay? That will take you to an agreement. Then you need another step to be traversed, which is agreement is not a contract necessarily. Okay? That agreement, as to section clause H, okay? That agreement has to be enforceable by law in order to be a contract. Okay? So you've got one more step. Okay, so it's an agreement, and then you go to a contract. So it's basically kind of you could say it is two steps away, right? So proposal is kind of like two steps away. Not an exact direct comparison because there is no offer concept in the ICA, but it's a very good question because it is similar to, the ideas are similar, and it forces you to look at what is the nature of a proposal, looking at the strict language of the ICA. You can broadly say that a proposal is kind of two steps away relative to an offer. Because offer acceptance straight away goes to contract. And this one here you have to jump through. You have to jump through a couple of more hoops, okay, before you get there to a contract. Right? So this is the answer to this question of what is the difference between proposal and offer. Okay. Now, now we'll go. Remember now, if you see what we went through, okay, where did we start? Okay, we started by what is the contract? Since you're talking about the Indian Contract Act, what is a contract? So it's an agreement. Also, what is an agreement? This reciprocal promises, full consideration for each other. Reciprocal. What is the promise? Proposal accepted. Okay, what is a proposal? Now you know what a proposal is. But we also use this other term here. What is an agreement? In defining agreement, we use one new term, promise. We also use another new term called consideration. Okay. Now what is this term consideration? So we have to define this as well, because the whole discussion is not over until we have broken down everything to a state where it's a very simple, plain definition, like the definition of proposal. So let's go down and see what consideration is. Now there is an elaborate definition in the ICA, so 2D. Okay. All right. So you can see this. This statement actually is well, it's not really a. You can keep it here. We'll talk about it later. So what is consideration? Here you can read the definition. It's a long definition. No point in my reading it out. It's on the screen. You can read it. And here you can see what is happening. You can break it up into different parts. I'm going to artificially break it up. Okay, so you can see this, okay? You can see how I've broken it up. What is happening? There is a promisor. Now, who is a promisor? A person who makes a proposal. Remember? Who is a promisor? Person making a proposal. Okay. So another thing you have to remember, if you follow my curveball, okay, and change the definition of promisor, person making a proposal become the proposer, it will have an impact on this 2D also. Okay? We don't have the authority to do it. Only the legislature can do it, but I'm just talking about understanding the implication of when there are interconnected ideas. This is a very common problem you'll find in many organizations, where you have to carry it through to the higher level of the organization as well, organizational processes. When a person is making a change in a particular process, he does not, very often does not think about what is the impact of this change on other processes, connected processes in the organization. So he happily just sits in his own silo and makes a change. And the other guys who are affected by it, they find out much later that there was a change in that process. So this is actually not good practice. When you make a change in a process or any kind of element of a structure, you must first look at all the connections that that element has, and therefore you should think through what will be the impact of all the other parts of this on the other parts of the system of your change, and only then should you make that change. So so just coming to this, so that coming to the desire of the promiser. So there is a promiser, person making a proposal. Somebody made a proposal, okay, and he has also, independent of that proposal, okay, he has also expressed a desire Okay, so this language is not very well, it could have been written better actually. So there are two things here. Desire of the promiser. Now the promiser is becoming, he's called the promiser because he has made a proposal. Okay. Now this desire that he has actually relates to what he wants in return for the proposal. Okay. Now who has he made the proposal to? Obviously the promisee, okay, according to the definition. It's actually the person accepting the proposal becomes the promisee, but it will be the same person to whom it is made. So he wants at the desire of the promiser. So he makes a proposal, and then he also communicates a desire to the promisee to whom the proposal is being made, that I want you to do. Okay, either you've already done something for me, or so when we say do, it includes not do. Okay, so we don't even have to look at the second part. Actually, it's understood. Okay, either past tense, you can think of it as a tense. Okay, past tense, present tense, does, done. Okay, this is past tense. This is present tense, and this is future tense. Okay. So this is past tense, future tense. So this is basically, and every time we write do, we don't even have to worry about to abstain from, because it's understood that it is included in do. Do means not do also. So add something, okay? It is something that is being done, which is being referred to as such act, okay? Or abstinence or promise, okay? Or promises. So this is basically again act or abstinence or promise, okay? Which is basically covering all the three tenses. Okay. So what he's saying is that the structure is basically like this. If you imagine the gardening proposal, that the promiser is the person offering to do the garden. Okay, he's saying I propose to do your garden 3 days a week. Now I would like you to offer. This is my desire, that you should now pay me. Okay, promise to pay me $100 a week. Okay, so in this case, it will be the future tense. You promise to pay me $100 a week. Okay, I'll see why the alarm is not. I don't want to detain you guys. Oh, I forgot to set the alarm. So it's 40 seconds late. Okay, so we'll start again with consideration in the next class. So your class is dismissed now. So those who want to leave can leave. The class is dismissed. And those who if you have a question, you can stay back. If you have a substantive question, we can deal with it, or we can continue in the next class, whatever. Anybody have any particular question at this stage? So I will write this as, and I will also try to move this into your, here, I'm just keeping a shorthand note of where we are ending just before consideration. And in this case, just started consideration, section A. This is 3rd March. So this is for my own thing. So this is also, you can also use it. Okay, the ending is what is more important. Okay, just started consideration. Okay. So we'll write that just started consideration. Actually, we have gone a little bit into it. All right. Okay. So that does it for this discussion for today. All right. Okay. So if there are no questions, then I will. Why am I getting this? Okay. All right. All right, folks, then in that case, so if there are no questions, I will stop the sharing. You can go and enjoy the rest of your evening. Okay, take care, and I'll see you day after tomorrow, I guess. Okay, so this note is already in your folder. Okay, and I'll just make one